Welcome back to the video series of Making International Law in Korea. I'll be explaining in this video the evidentiary value of the map in the territorial dispute and Dokdo. Maps generally have very limited evidentiary value in territorial disputes as affirmed by the international adjudications on those disputes. Map may have more evidentiary weight in boundary disputes than in territorial disputes. To get evidentiary value, a map should meet a basic conditions such as originality, accuracy, objectivity, and officiality. If a map lacks some of the conditions, the evidentiary value of the map could be reduced or not be counted. The purpose and the marker of a map are also important elements to be considered in deciding evidentiary value of the map. If a map meets above conditions fully and it is made by the government to represent its territory, the map shall have critical evidentiary value in a territorial dispute. Also, if such a map is attached to a legally effective document, such as a border treaty and a survey of national geography showing limits of its territory, the map can be assumed to have the same evidentiary value as a document. Regarding Dokdo, Takeshima between Korea and Japan, although there is no map that has critical evidentiary value, numerous maps are used to arguments and making strong its claim on territorial sovereignty over the island on both sides. Despite both Korea and Japan invoke many maps made up to late the 19th century to argue Dokdo belonging to their territory, almost all of the maps have a very limited or no evidentiary value in deciding territorial sovereignty over Dokdo because they cannot satisfy some of the above conditions. The March 29, 1877, the directive that Daijokan, the Grand Council of State in Japan, then Japan's the highest decision-making body, issued in response to inquiry from the Ministry of Home Affairs and Shimane Prefecture concerning Takeshima. At that time, the Takeshima means Ulleungdo and Dokdo. Answering the inquiry concerning the island legislation of Takeshima, Ulleungdo, and another island in Sea of Japan, Daijokan stated in his order that, with regard to Takeshima Ulleungdo, and another island that was the subject of an inquiry, bearing in mind that they have no association with our country. In this order, a map called Iso Takeshima Rakuju, rough map of the Iso Takeshima Ulleungdo, was also attached. This map proved that the another island of the order is the Dokdo. This map shall have the same strong evidentiary value with the order to show Dokdo as Korean territory. Let me touch upon the occupation international in Dokdo. Occupation of a territory was a mode of acquisition by which terra nullius could be acquired. Terra nullius include the land that did not belong to any states from the beginning and the land that was abandoned by a state. Occupation is described as original title to territorial sovereignty. It is said that two conditions should be met to establish a title to territory by occupation: intention for a state to act as a sovereign actor or effective control over the territory. There is an argument that the intention is not necessary because it can be generally presumed in express activities as a sovereign. It can be worth examining a few points as follows. The first, when does the title of sovereignty over a land be established? In the past, it was established with discovery, but conditions gradually become stricter. This is affirmed in many international adjudications, including award on Editorial Yemen arbitration in 1998, saying that the modern international law of acquisition or attribution of territory generally requires that there be an intentional display of power and authority over the territory by the exercise of jurisdiction or state function on a continuous and peaceful basis. I have to repeat this one again. Modern international law of acquisition of territory generally requires that there be an intentional display of power and authority over the territory by the exercise of jurisdiction or state function on a continuous and peaceful basis. The second, how does occupation and prescription can be distinguished? Acquisitive prescription is another mode of acquisition of a territory as derivative. A state may acquire a part of another state's territory by prescription. Essential to a claim of prescription is effective and long-established occupation. In practice, it may be difficult to distinguish the effective occupation and prescription. For example, in Alain Palma's case, the Permanent Court of Arbitration, and Eastern Greenland case of the Permanent Court of International Justice, the issue was not whether it relates to occupation or prescription, but which of two competing sovereignties had the better rights. The third, in modern international law, the occupation was used with the doctrine of recognition to justify colonization of inhabited lands. In a Western Sahara case, the International Court of Justice was asked to decide whether Western Sahara was terra nullius at the time of Spanish colonization. The court decided that it was not terra nullius because the people of the territory were socially and politically organized and the chief with the capacity to represent them. Fourth, it is not clear that a formal notice should be given to relevant state as a condition to establish title to land. Regarding Dokdo, Korea based its claim not on occupation but on inherent territory doctrine. Korea maintained that Dokdo belonging to its Korea since immemorial period. Thus, it does not necessary for Korea to invoke occupation as a mode of occupation. Meanwhile, Japan's position is somewhat vague and even contradictory. The Japanese government claimed that its sovereignty over Dokdo was established in the 17th century, and it was reaffirmed in 1905 by cabinet decision to incorporate Dokdo into its territory and notice of Shimane Prefecture implementing that decision. However, that 1905 decision of cabinet based on its intentional consideration that Dokdo at the time of terra nullius. Japan does not claim occupation as a title territory anymore because there are many historical records of Korea and Japan before 1905 that evidence Dokdo as Korean territory, or at least both states recognize the existence of island. For these reasons, the Japanese government claimed that the measure of 1905 reaffirmed its sovereignty over Dokdo. Lastly, the waters surrounding Eodo have been recognized by states around the Northeast Asian seas, not only as a major slug, the sea lane of communication, but also as a primary maritime zone for military and strategic activities. Eodo is not an island as defined under Article 121 of the UNCLOS, but mere underwater reef. However, because of name Eodo, often known as Parangdo, including the Korean word do or island, it is highly likely that those who do not know can misconstrue it to be an actual island. Yeodo is marked as a circular rock in international charts. However, even the words rock and unculus refer to a very small island, which is always lying above the sea level. Thus, even the name circular rock can lead misconceptions regarding its true nature. Yeodo does not bear the status of island under the provision of the UNCLOS. Therefore, any claim of sovereignty over Yeodo or effort to make it a base point for establishing maritime jurisdiction zone, for example, territorial sea, exclusive economic zones, and continental shelf, including expanding maritime jurisdiction, are without legal effect. The other problem is not a sovereignty issue under international law, nor is it a simple maritime jurisdiction issue. The Korean government recognized the significance of Yeodo and surrounding waters by constructing an ocean research station which has been in operation since year 2003. The Yeodo Ocean Research Station is a fixed structure in jacket form, located about 700 meters south from Yeodo and 40 meters in depth. Its upper portion is approximately 1,320 square meters, consisting of a cellar deck for equipment of facility installations, a main deck for living quarters and laboratories, and heli deck for rescue operations equipment and human transport. The Chinese government in the year 2000 and year 2002 raised objections through diplomatic channels concerning Korea's construction of Ocean Research Station. And on September 14, 2006, during a foreign ministry, a briefing Chinese government stated that a suancha, which is a Chinese name for Yeodo, was a leaf, which is where Korean and Chinese EEZ overlap, and that any unilateral act of Korea on Yeodo would have no legal effect. While on the other hand, Chinese representatives stated that as an underwater leaf, there is no territorial sovereignty dispute between Korea and China over Yeodo. At the same time, he also expressed the view that China wanted to settle maritime jurisdiction issues through dialogue. Recently, in addition to making unreasonable demands for Korea to stop the salvage activities undertaken by two Korean vessels, the Southeast Yeodo last April and a couple of times, China also sent Chinese state vessels to the area. I'm going to give you a wrap-up for this week's lecture series. The point made reveals the two-sided nature of Korea's position in relation to territorial issues of Dokdo, where Korea is a disputant. It is prudent to approach the understanding of international law from the perspective of the current prevailing international law regime, which is based upon Eurocentric positivism. However, this approach lacks appreciation of Korea's historic experience that include injustice of the Japanese annexation and colonialism. The task for Japanese international lawyers is to challenge the existing international law regime by promoting perspective on international law that not only take into account historical injustices and historical experience of formerly oppressed countries like Korea, but also seek to bring the international system up to standard of justice that is fair for all. Though there are scholarly approaches that raise this issue in Korea, which has emphasized the historical consciousness and decolonization, in order to formulate this as a comprehensive theoretical perspective, more needs to be done. The term historical criticism approach, which was a term that appeared in a recent judgment of the ICJ, is an encouraging indicator that should inspire international lawyers to employ this approach when dealing with the territorial issues Korea is involved in. It is a disciplinary project devoted to the academic task of revisiting, remembering, and crucially interrogating the colonial past.